My name is Lindsey Obenhaus, and I'm a divorce and family law attorney at Goranson, Bain, Ausley. Being a divorce lawyer, people often come into my office and tell me they just want their half in the divorce. And I have to tell them that's not exactly what our law provides for us. Our family code says that community property should be divided in a just and right manner. That doesn't always mean 50-50. This leaves it up to our courts to determine what does just and right mean in each specific case. When determining what just and right means, a court will usually start first with considering if there's fault in the breakup of the marriage. These are usually the salacious facts that you hear about. If someone had an affair, if someone may be hiding money and not being truthful to their spouse, or maybe someone has a gambling problem. These facts can be used to justify a disproportionate division to the wronged spouse in that relationship. Courts can then be creative on what they can consider in dividing community property in a divorce. One popular thing that we see is considering the age, education, and employability of spouses. For example, if you have a 45-year-old stay-at-home parent who's been out of the workforce for over 10 years, his or her financial future may look a lot different than their spouse of the same age who may be in their prime earning years. The court may use a disproportionate property division in that case to justify what's just and right for their financial futures, to make sure they're both going to be fine going forward. You may still be wondering, why can't there just be one set of guidelines or formula in our code to help fix this? And the answer is that there can't be a one-size-fits-all solution to fixing injustice or inequality, especially as our views on this change over time. The vague wording of our statute allows this law to serve generations before us and likely to serve generations ahead of us. An interesting case to see this at play is the 1929 case of Ferris versus Ferris out of San Antonio, where the court used an unequal property division to fix the so-called helpless state of the wife after the divorce and its views on women at the time. When Reba Ferris was divorcing from R.C. Ferris, she was awarded little more than her sewing machine and $50 a month in child support because she also had custody of their child and was pregnant at the time. R.C., on the other hand, was 30 years old, received over 1,000 acres of property and all the money in the bank. When Reba went up on appeal, complaining that the property division was not enough, the court overwhelmingly agreed with Reba, saying that Reba had given up her youth, her intelligence, her freedom, and was not able to re-enter the workforce. R.C., on the other hand, had given up none of these things, and he shouldn't be able to escape the consequences of his marriage scot-free. So the court awarded Reba a significantly larger share of R.C.'s land to try and fix the so-called handicap that she faced after the divorce. You may be wondering what kind of property is divided in a Texas divorce case. A Texas court will divide all community property in a just and right manner. Community property is presumed to be all property at the time of divorce. That's not separate property. Separate property is property belonging to a spouse that's acquired before marriage, by gift, by inheritance, or by virtue of personal injury. Let's give you a few examples, assuming that Reba and R.C. are a modern-day couple. If Reba inherited a necklace from her grandmother during the marriage, that would be a piece of Reba's separate property because it was acquired by inheritance. The court could not take that necklace from Reba in the event of a divorce, and it wouldn't be factored into the property division. However, let's assume Reba and R.C. bought an iPad during the marriage with R.C.'s income. They both used it and maybe watched Netflix on it. The court would have to determine then whether it's just and right for Reba or R.C. to be awarded this piece of property because it's community property. Let's give you a trickier example. Let's assume that R.C. owned a vehicle prior to marriage. When he got married, had a baby, and hit it big with Reba, maybe he traded it in during the marriage and put money down to purchase a new car. This new car then is part separate and part community. This commingled asset would be treated like this in a divorce. R.C. would probably be reimbursed the separate property value of his trade-in, and then the court would decide which of them would receive the community property value of the new car that he purchased. As you can see, dividing property in Texas is not as simple as 50-50. The next time someone tells you they just want their half in the divorce, you may want to tell them to think again.